All right, my friends, we just pressed the Let's Go Live button, which means we've got to wait for the stream to fire up all across the fruited plain of the interwebs before we go ahead and get started. Got to make sure those tubes are working. Sometimes they are not. That's a problem. But it looks like they are today. That's tremendous news. That means we can go ahead and get started. So let's do it, shall we? Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney. And today we're talking about Jack Smith and the clock ticking away. Time almost up for Jack Smith to prove that he is lawfully and constitutionally appointed, because we've got a hearing coming up in Judge Cannon's courtroom in just a few weeks from now, and all of the final briefs are coming crashing in. So we've got some new ones to attend to from Ed Meese, former Attorney General for the United States, and Trump. His defense team also submitted a supplemental. This is the classified documents case, and this is about whether or not Jack Smith should even be a Jack Smith, a special counsel. Answer is no. He was not lawfully appointed by the president. He was not confirmed by the Senate. Instead, they cobbled together some Reno regulations, other portions of the United States Code, to say that he's got these magical prosecutorial powers, even though he's usurping the appointment and the appropriation clauses of the United States Constitution, meaning he's illegal and he's taken money that doesn't belong to him. So we're going to read through both of those filings. Those are in Judge Eileen Cannon's courtroom, and we're looking forward to those because the hearing is coming up on this one on June 21st. Whoo, that's coming up soon. Just about a week from now, we're going to have oral arguments in Judge Cannon's courtroom. So the final briefs are here. We're going to look through them because we're excited about that. Then we're going to see what's going on with Nathan Wade in Fani land down there in Fulton County, Georgia. This is a screenshot, a GIF that I made of Nathan and someone from his team, I think his lawyer, having a little powwow over there in the corner. And we don't know if this is bro talk or pro talk. Remember, we had that distinction during the trial. There was the pro, that's attorney-client privilege, and there's the bro, which is his friends. There is no attorney-client privilege. So I don't know what this is going on here, bro talk or pro talk, but what's so strange about this situation is they did that right in the middle of an interview. In fact, he was sitting down with Kaitlyn Collins, and I think they probably thought that she was going to cut that out and just say, oh, they just had a break. We'll just, cut. She didn't do that. She posted it right on X and said, this is a little weird. I asked him a question. Someone flags him down. He goes and does a little side conversation with his bro or pro, and then comes back and refuses to answer the question. Very strange. So he said, I think we don't need to be distracted. Oh, that's what you had to have a conversation with that dude for? Okay. So we'll see what that looked like. But we also have Fani Willis, who is very upset. Wild filing from her. So remember that in Georgia, the question that we have is whether or not Fani should be disqualified because of her love affair with Nathan Wade, which was something that tainted the entire case from the very inception. He got $700,000 plus, and you'll see if he's worth that or not in this interview. We'll see if it was worth what she paid for that or something. And so we'll see that. But also Fani is very mad with the Court of Appeals. She says, how dare you accept and grant the appeal coming up from McAfee's courtroom? She tells them that it was improvidently granted. Okay, so she tells the Court of Appeals, you guys were improvident in improvidently granting the appeal. So she's saying, undo what you did. So she's telling them to reverse themselves. A lot of bravado, this woman. Maybe they're oppositional to God also, and probably racist as well. I don't know. Maybe she's sleeping with someone over there too. Who knows? Okay, we got a third segment. Congress is doing something about these prosecutions. We'll see if it goes anywhere. But the Judiciary Committee over at the GOP, they said, all right, look what has come out of our committee now. We have emerged with this bill that is moving forward in the House out of committee. H.R. 2553 is about stopping political prosecutions of presidents and vice presidents by state prosecutors. And the theory is if you have a Fani or Nathan Wade, or if you have a Tish James or an Alvin Bragg or any one of these weirdos, what you do is you remove that from the state court up into federal court to take that out of their jurisdiction, out of their purview, and hopefully get some sense in the whole thing. We'll take a quick look at the bill. It's very short before we get some reaction because they were discussing this in Congress. And there was this great montage of all the political attacks. And we'll play that clip just to show why this type of stuff is important. It's no longer the justice system as though it's interested in justice. No. Just like education, Department of Education is not really interested in educating anything. Or the Border Patrol, border immigration, not really interested in securing the border. Why would the Justice Department care about justice? They don't. So it is necessary to get some control over this. Congress is investigating, and this guy, Norm Eisen, was in there, and he's just a mega TDSer. So we'll listen to what he says. And then we'll wrap it up with this FEC guy who was not allowed to testify in the Alvin Bragg prosecution, but he is now explaining what a joke the Bragg prosecution was. Because remember, a big part of the predicate offense, at least in speculation, in theory, we don't even know what the ultimate object or predicate offense was in the Bragg conviction. But the FEC chair came out and explained that had he been able to testify, they would have been able to show that there was no evidence of criminality at all. And there's all sorts of other problems, which was the point, which is why he wasn't allowed to be there. So we'll go through all of that. As you can see, we got 3 great segments here today, my friends. And I hope you're having an awesome week. It's Thursday. We know what that means. Tomorrow is a Friday. We're always happy about that. So before we get into all of the news today, let's get an update on this bird flu situation. All right, 100 million birds are dead. Poultry industry could serve as another example as dairy farmers confront bird flu. And so this continues on. They're talking about raw milk and all the things, so be cognizant about this. But earlier bird flu outbreaks have started and they forced a slaughter of tons of animals. Hot spots still occur. It's a big deal. Now, this is the thing, right? It may not impact humans at all. We don't know. But the question is, how can a 1,500-pound cow and a 5-pound chicken have the same illness? And the question is, can a 180-pound Rob also get the same thing? Well, I sure as heck hope not. But if that does happen, your boy's going to be prepared because I've got my prescription contagion emergency kit over from our friends at the Wellness Company. And this is the only kit of its kind that will provide you with a carefully selected assortment of effective medications. All sorts of stuff is in here. Things for bird flu, COVID, other respiratory illnesses. You don't even know what's going to come. So it's got ivermectin, hydroxychloroquine, Z-Pak, Tamiflu, budesonide, nebulizers, all sorts of good stuff, plus a guidebook so you know how to use it safely. It's backed from research by experts like Dr. Peter McCullough. You know who he is. And every American should have at least one of these kits at home. Ordering yours is extremely easy. It takes less than 2 minutes. Couldn't be simpler. Go to the link in the description below, twc.health/Robert. It'll take you to this website. Use code Robert when you check out to purchase your kit, and you'll save 10% off, plus you'll get free shipping. It is very easy. twc.health/Robert. Use code Robert, and these kits are only available in the USA. So check them out, my friends, at the Wellness Company. Links in the description below. All right. And so now it's time to get into the business of the day because we got some filings to read to, and we always love that. Yes, we do. Jack Smith is up against the ropes. The clock is ticking. Now he has to justify his entire existence. Why is he even here when he was illegally appointed as the special counsel? Why illegal? Well, because the president never appointed him in the first place, and the Senate never confirmed him. And we have this little pesky thing in America, or we thought we did, called the U.S. Constitution that says by the statute, by the language in the document, that they have to follow appropriations and appointments mechanisms in order to get him in a position like this. And they did not follow that. So we know Judge Eileen Cannon has scheduled a proceeding for oral arguments from both sides. So Trump's people will be there. Former Attorney General Ed Meese and his people will be there. And Jack Smith and his prosecutors will be there, all for oral arguments on June 21st, just a few short days from now, to have a hearing on Trump's motion to dismiss this indictment based on the unlawful, illegal, unconstitutional appointment of Jack Smith. Going to be short oral arguments. We got 30 minutes for each side. Seating is going to be reserved for representatives. Everybody presenting arguments. So, it's going to be a good one. We're waiting for this because this has been a battle that Ed Meese and many others have been submitting and fighting for a long time. And Trump has recently joined the fray. And so let's see what is happening from these filings. So you'll notice the first one we'll jump into is from Trump. And then we'll go to Ed Meese in the second half. But Trump submitted this one. We know Southern District of Florida, Judge Eileen Cannon presiding, West Palm Beach Division, United States of America versus Donald Trump. This is Trump's supplemental submission. So we've already read through the prior filings, and if you miss those, they're excellent. Many from Ed Meese. If you search on our channel, you'll find them. But here is the supplemental, because Cannon said, all right, we're going to have a hearing on this. No problem. Come out here and bring everybody to come argue this thing. But I need some more information. So send me some more stuff, and here it is. They say, all right. Good morning, Your Honor. This is President Trump, and we're here respectfully submitting the supplemental brief because you asked us to. You wanted some more information about this case called CFPP versus Community Financial Services, and so we'll clarify this for you, Judge, right now. They say this Supreme Court case called CFPB further supports Trump and Trump's motion to dismiss. In fact, it supports the fact that Jack Smith is illegal. First, under that case, they say that the DOJ's permanent indefinite appropriation is not available to fund Jack Smith's case. They call it an election interference mission because the designated purpose of the appropriation, which is the money. So remember the DOJ, just to zoom out on this for a quick second, they're tapping into all of these other funds and all these other powers. There's no statute, there's no provision in U.S. code that says the special counsel is authorized by Congress and you get this money, from these accounts. They don't say that at all. So what the DOJ has done is they've cobbled together a bunch of statutes, like 6 or 8 of them when we went through the last filings. And they've said, well, if you read these all together, it kind of gives us these powers. And then they say their money comes from this other fund that really is limitless, which is also outside of the appropriations powers. What? Unlimited money? Where does that happen? Because Congress has to appropriate the money. That's their power, not the executive branch. Okay, so if Congress didn't create the special counsel's office and they're just ripping money off from somewhere, then both of those things are problematic. So they say the appropriation does not encompass Jack Smith's politically motivated work. We're not paying for that. And second, although that case rejected the association respondent separation of powers arguments under the appropriations clause, saying that maybe Congress has the power and the executive branch doesn't, the Supreme Court's analysis of that issue does not apply in the context of a motion brought by a criminal defendant with important constitutional rights that must be protected. So this case doesn't sound like a criminal case at all. It sounds like CFPP versus Community Financial Services. So that's not a state or a prosecutor versus a defendant. It sounds like civil litigation. So they're saying, well, why are we even talking about this? This is a criminal defendant with constitutional rights, so it's not exactly the same. And third, Trump also agrees, Judge Cannon, with Your Honor's suggestion that the threshold issues in Trump's motions based on the appointments and appropriations clauses are purely legal questions. We agree. However, the argument by Jack's office that the DOJ could have drawn on other appropriations, so Jack Smith says, well, maybe we shouldn't have been using that money, but we could have drawn on other appropriations to fund Smith's office, would require the court to make fact findings supported by evidence from the DOJ or the special counsel if it's necessary to reach that issue. So saying, yeah, we don't think you need to dig into this. You don't need to go and find out where the money came from and all these things. You could just decide, we don't need an evidentiary hearing with witnesses and evidence. We think you can just look at the law. It's clear. This is how Jack Smith came into power. This is the documents that they sign and the power they claim. Here's what the law says. It's just a legal fact, legal question. But if you need to go in and we need to dig into where this money, okay, yeah, we might need to do that as well. But saying, all right, Cannon, so let me just give you some more background, Judge, if you want. In this case, the Supreme Court held that the appropriations clause, which is where the money comes from, they said the way this rule works is it requires, quote, a law that authorized expenditures from a specified source, in italics, so you got where to come from with some specificity, and the money needs to be designated for designated purposes with some clarity. Not Jack Smith can have an unlimited credit card for whatever he wants. Under that analysis, the question is whether the text of the pertinent law contains the requisite features of a congressional appropriations. Now, for the purpose of this case, in Trump's case, the pertinent statutory text is the permanent indefinite appropriation, right? So there is no specificity that the DOJ is using to fund this sprawling, politically motivated lawfare by Jack's office. They tell us, provided further, and where does this come from? They tell us, provided further, that the funds appropriated to the DOJ in this act not exceed $1 million may be transferred to this appropriation to pay the expenses of independent counsel, which is different from special, no longer valid, upon notification of the AG on appropriations of the House of Representatives, and provided further that a permanent indefinite appropriation is established. Okay, so this is where the money's coming from. A permanent indefinite appropriation is established, like a limitless credit card with no limits, within the DOJ to pay for all necessary expenses of investigations and prosecutions by independent counsel, which again doesn't exist anymore, or other law. So that's their power. Judge Cannon, are you kidding? The rules say that the Supreme Court says it has to be specified. They wrote that in this case, and it needs to be for a designated purpose. Just if you're missing it on the screen, just to be ultra clear. But the special counsel says, no, it's indefinite appropriation for whatever investigations and prosecutions that the independent counsel or other law allow us to do. Huh. So it sounds like that is not in comportment with the Supreme Court, which we just double circled. Sounds like Jack's illegal. So because there are no more independent counsel appointed, because that act lapsed because it was a terrible act, Trump's motion requires analysis of the two phrases. What does other law mean? And what does lowercase independent counsel mean? So they say, all right, Cannon. Now, for the reasons set forth in Trump's motion to dismiss based on Jack's illegal appointment, the DOJ's, quote, permanent indefinite appropriation is not available to Jack because he was not lawfully appointed pursuant to this other law. He doesn't have access to those funds. The appropriation specifies the objects for which the DOJ can use those funds. Now, Smith's election interference mission is not one of them. And so thus, Smith's appointment does not satisfy the first textual requirement for accessing the money. He doesn't have access. Now, the fact that Smith is not an independent counsel under the permanent indefinite appropriation serves as a second alternative basis to grant Trump's motion. In this regard, Jack's office is seeking to have it both ways. They're emphasizing the Attorney General's control over Smith. So they say, whoa, no. The Attorney General does have some power over Jack Smith, and therefore it is a valid appointment and survives Trump's appointment clause challenge, but also eliding those authorities to support a flawed independence argument for the appropriations clause. Now, specifically under the appointments clause, Jack argues that Smith is subject to the direction and the supervision by a presidentially appointed and Senate confirmed officer. Okay, so maybe Jack Smith, his argument is, okay, well, so what if I wasn't appointed by Joe and confirmed by the Senate? Who cares? My boss is, Merrick Garland was, so eat it. I'm subject to his supervision. But they also say he's independent, so Merrick Garland is not really orchestrating anything. Now, the office summarized their control as follows. They said the Attorney General supervises the special counsel's work. Oh, that's interesting. So he's not independent at all, is he? May remove him from the office, may review and countermand his decisions. And as an additional means of exercising control, Merrick Garland can rescind the regulation at any time, or amend the appointment order, or exercise direct statutory supervision over Jack Smith. So it sounds like Jack Smith's kind of like an employee of Merrick Garland. So he's not independent at all. Interesting. Now, so why does he have access to that money? So in another opposition brief, they then quoted the final rule from the Reno regulations, which is where they think they have their power, regarding the balance between independence and accountability, right? Some independence. Now, the final rule confirms that the Reno regulations eschewed what the office describes as a significant statutory freedom under the DOJ supervision. Now, the Independent Counsel Act has lapsed. Under the Reno regulations, and just to be clear, I know we're moving fast here, but the Reno regulations were from Janet Reno. She said, we can create these special prosecutors because of these other laws. And she created regulations. So the way that we have these things is we have a constitution, we have U.S. code, which is supposed to pass laws in alignment with the Constitution. So we have all these U.S. statutes that give authority to certain things. And then we have the Code of Federal Regulations, which interprets or explains how to apply the U.S. code because they're not clear, right? We have Congress people writing the laws. You're like, oh, what the hell did they say in there? So we have to have essentially regulations, which are the interpretations of the U.S. code. So Reno came out and said, well, I'm looking at all these codes and I'm going to say we have these powers. And she created regulations that created, in my opinion, powers out of thin air. Now, they're explicitly cited in the order appointing Smith. So they're various U.S. code provisions saying the ultimate responsibility for the matter and how it's handled will be with Merrick Garland. And so they acknowledge in there the possibility of a review of Jack's work. So put simply, the office has touted Jack's lack of independence in response to the Appointments Clause challenge. So they say it's not an illegal appointment because he's just an employee of Merrick Garland. So he doesn't need to be appointed. But for the purpose of the other challenge, so now we say, so he works for Merrick. Okay, well, what about the money that Jack Smith is spending, which is tens of millions of dollars? Then suddenly the Jack office says, oh, well, we're independent. That's why we can access the money. And it ignores the importance of the Attorney General's ultimate responsibility for Jack. Now, instead, the office goes to Black's Law Dictionary and says that independent counsel are simply attorneys who provide an unbiased opinion or conduct an impartial investigation. So they say Jack is an independent counsel. So he counts. So that's why he can access the independent counsel money, even though there are no independent counsels anymore. In an ideal world, those are hardly distinctive features for any attorney, okay? Acting on behalf of the U.S. government. So don't act like it's like, wow, you're a U.S. attorney. You're acting in an unbiased way. Wow, shocking. You all should. Prior to Smith's appointment and his politically motivated lawfare, most people would have expected all DOJ attorneys and independent counsel alike to behave in that fashion, not like corrupt partisan hacks. Thus, if the office is correct and the expectation of an unbiased and impartial behavior is all that the term independent counsel requires, like that's it, you just got to be like a good dude, then you're good. If that's all it requires, then the DOJ's permanent indefinite appropriation lacks the designated purpose. So you can't have it both ways. Like the money needs to be for something. And if the money is only for like good bro, honest dudes at the DOJ, yeah, man, then that's not good enough. We need like, what's it for? Indeed, under the office's argument, the limiting phrase in the permanent indefinite appropriation, the credit card without a limit on it, would be devoid of any content. Okay, independent would just mean an ethical guy, as required by the state bar. You can't even have a license if you're a piece of crap, which is that's a loose rule, which is a statutory instruction that is to be avoided under well-settled law. Now, contrary to Jack Smith's manipulations, okay, the term independent in the DOJ's limitless credit card should be interpreted in accordance with its plain meaning, which is entirely inconsistent with the Attorney General and their oversight as mandated by Reno. Independent should mean independent, not mean work for Eric Garland. The GAO's analysis of Patrick Fitzgerald's funding made that clear, so this is a different case. They said they looked for indicia of independence. Were you actually working for them? In contrast to Smith, when we had this other counsel, special counsel called Fitzgerald, he operated under express exclusion from the Reno regulations. And he did not need to follow department practices or procedures. He was outside. And because Smith was not appointed under the other law, he's not independent. And the DOJ's funding of this permanent limitless credit card violates the Constitution. And finally, Judge Cannon, the separation of powers also does no violence to Trump's reliance on that doctrine. In the Supreme Court case, the court focused on the fact that the Appropriations Clause presupposes Congress's power over the purse, and the respondent associations offer no defensible argument that the Appropriations Clause requires more than a law that authorizes the disbursement of the funds. Now here, Trump's argument is that the DOJ expressly promised Congress that after the lapse of the Independent Counsel Act, attorneys acting as lowercase independent counsel would be part of the department's budget. Now, as set forth in our brief, Congress chose not to renew or to reinvent independent counsel, and so there is no more money for that. There, the DOJ itself created a separation of powers problem by failing to make good on its assurance at the hearing. And so, Your Honor, if you think that we need further investigation, we'll consider it. It may be warranted. Now, we agree that these should not, though, require factual development. These are just legal questions. And Your Honor, you're a judge. You don't need to go find new facts. Under either clause, both of these items require a dismissal of this entire case because Jack is not the right prosecutor and he shouldn't have had any money for this. However, in response to Trump's motion based on the Appropriations Clause, Jack Smith has said that they could have drawn on other appropriations, so we could have gotten money over there or money over here. Now, contrary to their claim, we very much dispute that point. They can't get their money from anywhere else. We've done our research. The court should reject these series of attenuated sites and authorities because they rely upon a failed effort to suggest that Trump has not been injured by this Biden campaign surrogate lawfare trying to harm Trump. It is unlikely at best that there was any source of funding at the DOJ that could have funded this sprawling, politically motivated activity that Jack Smith has undertaken because Biden handed him a blank check. As we've already noted, Judge Cannon, and as with any government agency, the realities of bureaucratic resource limitations have constrained the DOJ's work in the past. Money stops them from going hog wild. And therefore, to the extent the court reaches this issue, the DOJ and the office should be required to substantiate their position. If they say that they can get money from elsewhere, they should prove it. Where would that money come from? And schedule an evidentiary hearing. Signed by Todd Blanche, Christopher Keese, Trump's defense attorneys out in Florida. And they're not alone. The team that really brought a lot of this to the light and to the attention of the public are our friends Ed Meese and their team. And this gets filed by Edward Trent out at Scherer and Jaffe, counsel for the amici curiae, who are Ed Meese and others. And so here is the supplemental filing from the former Attorney General of the United States, who also makes the point that Jack Smith is illegal and unconstitutional, and his money was illegally converted from us to him. This is the supplemental brief. Former Attorney General Ed Meese and Michael Mukasey and law professors Calabresi Lawson. We also have Citizens United as amici curiae supporting Donald Trump's motion to dismiss the classified documents case. All right, Judge Cannon, great to be in your courtroom yet again. This is the team, Meese and Co. We're submitting this supplemental brief because you asked us to. Now, Jack Smith's argument to this court is pretty flawed. Why? Well, it fails to address the fundamental problems that we've already identified here. First, Your Honor, it is clear that the position that Jack Smith holds was designed during a time when the executive branch gave little to no thought to the Appointments Clause. But that's their problem. Even so, nearly all the special prosecutors appointed during the past 40 years, aside from Smith and Mueller, all of them have been lawfully appointed pursuant to the clause because they were already serving as Senate-confirmed U.S. attorneys. Already serving. So if you are going to be a U.S. attorney, you got to be appointed by the president, confirmed by the Senate. We're having a bunch of debates over this right now, when the Senate saying we're going to refuse any of your U.S. attorney nominees moving forward until you stop this political lawfare. Shout out to J.D. Vance and the rest of them. So good news. But guess what? Mueller was not. But Mueller at least had been a U.S. attorney before. And at one point, had been appointed and confirmed by the Senate. But Jack Smith has not. Second, notwithstanding Smith's arguments, His entire office is not properly established by law, as that phrase was understood during the founding era. And third, this case reconfirms Justice Jackson's reasoning on the importance of Senate confirmations and why you need this, and why the special counsel in this made-up position poses far too much of a danger to escape the accountability protected by the proper application of the appointments clause in the first place. All of this reaffirms that Jack Smith and his appointment is unconstitutional. Canon, Your Honor, history shows that Jack Smith type appointments generally do not suffer from the same constitutional infirmity as Jack Smith's. We've done this before. Contrary to Smith and his attempt to portray the authority of his appointment as being supported by long-standing precedent, Jack's like, we've done this all the time. You guys are making a big deal out of nothing. In fact, the legal basis for his appointment is a vestigial holdover of a bygone jurisprudential era. It's antiquated, Your Honor, and not relevant today. And that legal flaw likely went unaddressed. So they're saying, well, we've been doing this for so long and no one's made a problem of this. It went unaddressed because, with only one exception, each special prosecutor for more than 40 years before Smith's appointment was in fact duly authorized by the statute. So nobody complained about these rules because everyone was actually following the rules that should have been in place. Let's walk through the history, Your Honor. The pertinent history begins in 1974, when, without examining the requirements imposed by the Appointments Clause, the U.S. Supreme Court in U.S. v. Nixon briefly mentioned that the Attorney General had appointed a special prosecutor in that case. The court did not indicate the disapproval of that method of appointment. So back when Nixon was around, they just appointed a special prosecutor. How do we do it? Here's one. And then there was a Supreme Court case, but nobody brought up that appointment in that case. The question presented in the Nixon case didn't even include that. Nobody questioned it. Nor did a single statement in that decision suggest any contemplation of the pertinent constitutional requirements imposed by that clause. So they're relying on Nixon. Well, they're saying, well, the Supreme Court reviewed a case kind of like this where there was another person, but they never even brought it up. Nobody challenged it. It was not until 2 years later that the Supreme Court inaugurated the modern era of the Appointments Clause analysis in this case called Buckley versus Valeo. It was a pure curiam opinion, so we don't have an official person right. It's the opinion of the court, so it's nobody's taking ownership of the opinion. And the court has continued to develop that area of law, most recently in 2018 and again in 2020. So suffice it to say that today, the Supreme Court takes the Appointments Clause far more seriously than it did in 1974. Nobody cared about it back then, but the courts do now. They're talking about it every 2 years so often. So from 1978, Judge Cannon, through 1999, moreover, special prosecutors were called independent counsels, and they existed because they were appointed under a statutory provision to an office that the Supreme Court upheld as an inferior office in a 1988 case. But that statute, okay, the independent counsel statute, which is not the basis for Smith's appointment, is gone. It no longer exists. And Morrison is therefore not controlling here. So you can't take this deleted case essentially and use that as precedent. So from 1999 until present, with only one exception, which is Robert Mueller, every special prosecutor now called special counsel who was appointed under the Reno regulations was a U.S. attorney, and as such was a Senate-confirmed presidential appointee who held office pursuant to the statute that creates the position of the U.S. attorney. So we have the Constitution, which says you can create other positions in this way. That's the Appointments Clause. And then the Congress passed other statutes that create, we have the position of U.S. attorney and rules for appointing that person. So all of those appointments were perfectly legal because the special counsel the designation merely added an item to the portfolio of the principal officer whose appointment conformed to the requirements of the Constitution. Now, accordingly, after Nixon and until this case and the Mueller case, There was never any occasion to consider the constitutional implications of vesting such enormous power in someone whose position was never created by an act of Congress. We can just bring in Jack Smith from The Hague and he can just suddenly indict a president and just run roughshod over the entire electoral process. It's ridiculous. Now, Robert Mueller, just to be clear on this, was in fact at one point a U.S. attorney. Checking my memory on that. Robert Mueller. Mueller has served both in government. He was an assistant U.S. attorney and a United States attorney and an assistant attorney general for the criminal division. So at some point, not at the time that he was in office, but when he became the special prosecutor, he was not an acting U.S. attorney at the time, but he had been previously. Now, Jack Smith was not. He just got appointed as an independent special counsel, but never confirmed as an actual U.S. attorney. Now, who never, right, this, and that was Mueller. But this new person, Jack Smith, comes out of thin air, never received their appointment by action of the President of the United States or consent of the Senate. From 1937, more research, until 1976, the Supreme Court invalidated few statutes and executive actions on separation of powers grounds. Okay. Now, in short, the idea of a chief prosecutor not authorized by a clear statutory provision or with approval of the Senate is a dinosaur. It should be declared extinct because they have no power. Like, where's the power come from? Now, Smith cannot deny that in 1791, the phrase established by law in the Appointments Clause meant you had to have a congressional statute. So you can't just cobble together regulations. Remember, it's Constitution, the Supreme, then we have U.S. Code, then we have regulations. They're using the regulations to say Jack can exist. No, it's got to be in statute because that's what the Constitution says. The proper application of the Appointments Clause, Smith's brief does not even attempt to rebut this, that we say it shall be established by law. That clause refers to a statute. And for good reason. No fewer than 14 provisions in the original Constitution use the word law in this fashion. Smith doesn't even try to address this. Now, moreover, an examination of the framers' history confirms that the power to create federal officer positions is specifically situated in the Necessary and Proper Clause, U.S. Constitution, Article 1, Section 8, Clause 18. And the powers provided by that clause are properly exercised only when Congress passes legislation that is then signed by the president. You can't have an attorney general named Janet Reno who just cobbles together stuff. Accordingly, it cannot be seriously debated that under the Constitution's original meaning, that Congress has the exclusive constitutional power to create federal offices. Only they can. Not Jack Smith. Now, as one of many examples, when this person called Elbridge Gerry suggested way back in the day, in 1787, we're going back in the time machine, there was a constitutional convention. Elbridge Gerry, he said, we should add a necessary and proper clause. We should add the phrase that no officer shall be appointed but to offices created by the Constitution or by law. So you just can't create a bunch of offices. Remember what we saw when Javier Milei got elected down in Argentina, and he's like, afuera, afuera, afuera. And he was pulling all the different entities off, right? These bureaucracies are just like viruses. They just, they infect and then replicate themselves. And so there's just this process, like a cancerous growth on a society where everybody just keeps elevating themselves and hiring their friends and giving themselves more money. So no, only the Constitution can create these offices. Only the law can. Who writes the law? Oh yeah, Congress. The addition was narrowly defeated only because it was unnecessary, right? So that didn't make it in there. But Buckley finally gave effect to the critical separation of powers rule that the only branch that can create an office is Congress, is the only branch that cannot fill that office. So Congress creates the positions, the executive fills them. Every officer appointed in the executive branch that does not arise directly from the Constitution then must be the product at least of two of the three branches working in concert. We separate power. Congress creates the office. Executive branch fills them. What has happened here? The executive branch created the special counsel's office, and then they filled them. Now, acting pursuant to its office creating power, Congress has created many offices within the DOJ. Congress has. And they did it by statute. You see this U.S. code right here. So it's Constitution, the Supreme. Then we delegate that from the Constitution. We then get the U.S. code. And Congress writes the U.S. code. So they've got U.S. code 503, created the Attorney General. Got it. 504, Deputy AG, Associate AG, which is who Matthew Colangelo was. Solicitor General, Assistant Attorney Generals, and U.S. Attorneys. Those are the offices, various heads of the DOJ components. And for a time, Congress authorized an officer called an independent counsel, but that does not exist anymore. But the only officer creating statutory provision authorizing the Attorney General to appoint an officer is a provision that governs the Bureau of Prisons. So this is part of the Reno regulations. They say, well, we can't appoint some people. Like we can appoint some people because the Bureau of Prisons can't. Saying the Attorney General may appoint officers and employees as he deems necessary for the BOP. But the provision covers the BOP only, the Bureau of Prisons. It doesn't cover the DOJ. So you can't extract from that and say that it's yours. Now, Smith doesn't dispute that, but instead he claims the power for his appointment lies in other provisions. Okay. But as amici and Trump's counsel have already explained, we read previously, none of those provides the kind of general officer creating authority for the DOJ. And none of the provisions that Jack cites provides the kind of general officer creating authority that Congress has given to other department heads. Other departments can create other things. But amici have already referred to those. No such statute gives the DOJ, beyond its Bureau of Prisons component, the power to do this. But if Smith's argument were correct, then this statute would violate the canon against surplusage, because Smith's statutory authorities would give the AG plenary, total unlimited power, office creating power anywhere within the DOJ. So if he can use that to do this, then he can do anything, including the authority to create officers without even following the statute. And that power would extend beyond the entire DOJ. That would be an enormous elephant crammed into a tiny little mouse hole. Now, Jack's broader argument also suffers from the same flaws as he submitted originally. His dearth of evidence regarding the original meaning, alongside his failure to reconcile his centuries-old citations and legislative history, is a total fail. Instead, his brief goes on at length about what some congressional staffers thought in the early 1900s when they wrote reports. They never even voted on those things. And none of those things were ever signed by any president at all. And he's going back to a bygone era when federal prosecutors had a fraction of the power they now possess. And he now seeks judicial support in a Second Circuit case from 1975, okay? A year before the Supreme Court came out with their landmark Buckley decision, which rewrote all of the Appropriations Clause jurisprudence. So those non-binding authorities should not even be considered to overcome the extensive evidence that the Appointments Clause original public meaning says Jack Smith lacks the authority to do what he's doing. He does not have the type of prosecutorial power wielded by Smith because he did not appropriately attain it. And so Judge Cannon, former AG Meese, says, this case also reaffirms Justice Jackson and his insights on why such vast prosecutorial power requires both a duly enacted statute and Senate confirmation. We have this for a reason. The conclusion finds support from this fellow, Attorney General Robert Jackson. 80 years ago, this is what he said. He was out there speaking. He was talking to the nation's federal district attorneys, which was the previous name for the U.S. attorneys. And here's what he said. It would probably be within the range of that exaggeration permitted in Washington to say that assembled in this room is one of the most powerful peacetime forces known to our country. The prosecutor has more control over life, liberty, and reputation than any other person in America. His discretion is tremendous. He can have citizens investigated, and if he is that kind of person, he can have this done to the tune of public statements and veiled or unveiled intimations. Or the prosecutor may choose a more subtle course and simply have a citizen's friends interviewed. Now, when he was exploring the specific powers, Justice Jackson continued. Future Justice Jackson, so he was a U.S. attorney. He was the AG of the U.S. attorney. He ultimately became a Supreme Court judge. Then he said, as the judge, as the justice, he said the prosecutor can order arrests, present cases to the grand jury in secret session, and on the basis of his one-sided presentation of the facts, can cause the citizen to be indicted and held for trial. He may dismiss the case before trial, in which case the defense never has a chance to be heard, or he may go on with a public trial. If he obtains a conviction, the prosecutor can still make recommendations as to the sentence, as to whether the prisoner should get probation or suspended sentence, and after he is put away, as to whether he is fit subject for parole. And he continued, concluding by explaining why anyone exercising this enormous federal power requires presidential appointment and Senate confirmation. And by the way, this is all true, right? This is why we have such a problem with bully, cheating, lying, hack partisan prosecutors, because they are some of the most powerful people in the whole country. And apparently they can do whatever the hell they want in Fulton County and other places. And they're using it to go after their political opponents. So the judge said this, now because of this immense power to strike at citizens, not with mere individual strength, but with the force of the government itself, the post of the Attorney General from the very beginning has been safeguarded by presidential appointment, requiring confirmation of the Senate of the United States. You are thus required to win an expression of confidence in your character by both the legislative and the executive branches of the government before assuming the responsibilities of a federal prosecutor. We got to make sure you're legit. And we need two branches of government before we give you the power of the whole government to go wreck someone's life. Jack Smith never had that at all. For all the reasons that Justice Jackson articulated with respect to U.S. attorneys, Jack Smith exercises the power of a principal officer, as they do, and as such requires both the personal nomination of the president, the executive, and the majority of the Senate. Smith has neither. But that's not all. Under Smith's claim of statutory power under 515 and 533 and perhaps other provisions, if he has this right, the Attorney General could create an entire shadow government within the DOJ by just creating offices out of thin air. For every position established by Congress, the Attorney General could invoke his power to create a new officer who would report exclusively to him, and he could implant that new officer alongside, or perhaps even with supervisory authority over, each officer that Congress authorized. The obvious answer to such a dystopian and frightening version that he can just create offices and appoint people in this top law enforcement agency. Congress created something entirely different. They created an agency that answers to the American people, that answers to their elected lawmakers and to their elected president. That's the face of democratic accountability. But Smith's argument claims that Jack Smith has unchecked unilateral power to do whatever he wants. Now, as we have noted, Your Honor, Judge Cannon, one shudders to think what abuses might have been condoned in the McCarthy era if attorneys general had unlimited and unchecked power to create inferior officer special counsels. And it's precisely to avoid these terrible abuses of power that U.S. attorneys have always, throughout all 230 years of American history, required nomination by the president and confirmation by the Senate. Now, recent history shows that people with Smith's title, or the independent counsel predecessor, could pursue a former senior agency official, White House officers, a president's son, and lower-ranking persons as well. But by pursuing a former president of the United States, who's the current leading candidate to be the next president, Smith's prosecution here shows that how he wields his power to profoundly alter the trajectory of a presidential election, he's doing it with the destiny of the nation. He is thus one of the most powerful officials in the entire U.S. government. The idea that he can exercise that enormous power without a Senate confirmation is intolerable. And even worse, the idea that he can do so without holding an office that was created by Congress is unthinkable. Your Honor, Judge Cannon, that reality is compounded by the obvious ease with which this problem could have been avoided. As suggested by Justice Jackson's observations, Attorney General Garland could have appointed a special counsel who is already a U.S. attorney, duly appointed to that office by the president with the advice and the consent of the Senate. That simple step would have avoided not only the serious constitutional problem that has now been thrust upon this court, but also any delays occasioned by the present and well-founded motion to dismiss. But why didn't he want to do that? Well, maybe because an actual real U.S. attorney would never have brought this sham case. For these reasons, and those stated in the amici's opening brief, the motion to dismiss this indictment should be granted. Please do it, Judge Cannon. Signed by Edward Trent on behalf of Ed Meese and the amici, all submitting their supplemental filings saying Jack Smith is illegal. He is unconstitutional. He was never appointed by the president, wasn't even ever a U.S. attorney. They dragged him out over from Europe when he was there prosecuting in The Hague, and he was the person willing to accept the assignment. Your mission, should you choose to accept it, violate the United States Constitution, go after our political opponents, spend a gob of money to bog him down, and get a trial and convictions before the election. Jack Smith says, I'm your guy. So they tried to shove this down our gullet, but now we've got Ed Meese and Trump's defense raising a ruckus on this, and Judge Cannon is going to be holding a hearing on it, and we cannot wait to get our hands on those transcripts. As soon as that hearing is over, we're going to be digging in on those and seeing what happened, because Jack Smith has got to go. We love it when you subscribe to our channel, so thanks for doing that if you haven't already. We'd also very much appreciate a like on this video. We got some great links down in the description below, but if you enjoyed this video, you're going to love our next segment. It's coming up right next. We're going down to Georgia, and we're going to see what Fani Willis is up to because her lover, Nathan Wade, botched an interview with CNN. So we're going over there. We'll see you on that video there on the next one and back here. We'll see you soon. All right, now let's get right to it, my friends, because we've got a little bit of a breakdown over there in court in Kaitlyn Collins' interview chambers. And so let's see what is happening inside. Fani's lover, Nathan Wade, has a tough time when he sat down for an interview with CNN's Kaitlyn Collins. You can see we're going to get to the full thing, but here is a break in the conversation where Nathan Wade was flagged down by the media person, the lawyer, friend, we don't really know, says, cut. So then Nathan Wade takes the pause and then gets a little bit of coaching. You can get out there and do it and just say this and just say that. And he comes back out and then basically refuses to answer the question. So it's like, what did you help him with? He says it's all a distraction. So we're going to watch this full meltdown here in a minute. But what else is happening is Fani Willis is also appealing the appeal. She's asking the the Court of Appeals in Georgia to reverse themselves from accepting the appeal. So they accepted the lower level court McAfee decision that refused to disqualify Fani. The defense appealed that. And now Fani says to the Court of Appeals, reverse yourself. You should have never accepted that in the first place. And so here is what this looked like from Fani's office. She sent this one in. She's very unhappy about this. And I don't think the Court of Appeals is going to like this. Says here in the Court of Appeals in the state of Georgia, Big Fani Willis is now moving to dismiss the appeal. She says it was improvidently granted. Oh, the judges are going to hate that so much. Your Honors, you guys are kind of dumb. Why did you accept this improvidently? Not good. On May 8th, this is Fani and her office writing. So this whole courtroom, Fulton County, the entire county is just a total mess. We know what's going on with Michael Steele, with Brian Steele, Mr. Steele, and Ashley Merchant, all there. But this is in Fani's courtroom now. And they're admitting this to the Court of Appeals. They say, on May 8th, this court granted the defense petition for appeal. Now, the case has now been docketed, and now Fani Willis asks the Court of Appeals to dismiss the appeal. It was improvidently granted due to a lack of sufficient evidence. It was based on explicit factual findings of the trial court, and we should reverse this acceptance. Now, the order concerned various motions to disqualify Fani Willis. Now, as the basis for this, the defense asserted that Fani had a conflict of interest. She had a personal relationship with Nathan Wade, who we'll watch in a minute. Now, the problem with the theory is that Judge McAfee, in his order, say that there's no actual evidence. So you can't accept this appeal because they didn't give you any evidence. Now, as both this court and the Supreme Court have repeatedly held, Georgia appellate courts will not disturb a trial court's factual findings when a trial court makes determinations about credibility and evidentiary weight. You cannot review those unless they're flatly incorrect. Citing some case law, you cannot substitute, Court of Appeals, your opinion on what happened for what the court said. Now, the state respectfully submits, Court of Appeals, with such due deference afforded to the trial court, that's McAfee's factual findings, there is no basis for a reversal of the order. So Fani is happy with the order. Fani's okay. She can stay on the case. Nathan's hot dog is out on the road talking with CNN. She's fine with that. The defendants want Fani gone too. No. You can't just get rid of one of the bank robbers, okay? They both have to go. They're both biased. They're both unethical. She can't continue on. So she says, no, it's fine. You can't reverse this. Now, this is particularly true given the substantial leeway that the trial court afforded the defense in even gathering and submitting evidence to support their various theories and arguments. So she's complaining about the underlying evidentiary hearing. They should have never been able to even get that info. In the trial court's own words, the defense were provided an opportunity to subpoena and introduce whatever relevant evidence and material evidence that they could muster. So the trial court, McAfee's careful and extensive evaluation of the record and its utter dismissal of the central evidence proffered by the defense forecloses any possibility of reversal. The question would be why? Because I guess she's saying the facts won't change, but the question is the law and the standard that McAfee applied to the facts could change. So that's what the court will be reviewing. Let's see if they get there. Now, the theory of the conflict was that Fani obtained a personal stake in the prosecution by giving her lover, Nathan's hot dog, $700,000 to prosecute the case. She personally hired him to lead the team, and she was sleeping with him, paying him a lot more money than the other white people. Now, the purported financial benefit stemmed, who she was not sleeping with, by the way, and who we think, at least. The purported financial benefit stemmed from meals and travel that Wade paid for while he acted as the special prosecutor. Appellants argued that the case was initiated, unnecessarily prolonged, in order for him to enrich himself, which is true, because they were going on cruises. I can't even imagine they were working. We looked at Fani's calendar. It was hysterical. She's like meeting with anti-corruption teams, like lunchtime, 2 hours. Who's that? Nathan Wade. Amazing. So she's also going to Belize, Napa Valley. She has cash under her mattress, loves Grey Goose, all the things. And if Nathan Wade would have ever said, hey, baby, there's no case here. We got to dismiss this thing. The gravy train is over. So the trial court found that the defense theory could not be supported by the evidence. Sort of, kind of wrong, though, because Nathan's gone now. They say the defense star witness, Terrence Bradley, was such an utter cipher of either credibility or useful information that the trial court felt compelled to discard his testimony in its entirety. That is a weird sentence. was such an utter cipher of either credibility or useful information that the trial court felt compelled to discard his testimony in its entirety. Okay. The court finds itself unable to place any stock in the testimony of Bradley because he was a liar. His inconsistencies, demeanor, non-responsive answers left far too brittle a foundation upon which to build any conclusions, other than the fact that, in my opinion, the dude's a liar. Bradley was the linchpin of their entire theory of conflict, but his lack of credibility, he lied, and his credibility was destroyed, meaning he's a liar. And he was saying that what Nathan and Fani were doing was above board, like they were beyond reproach. And then he got obliterated as a liar. So it shatters, I think it diminishes the lie. If he's willing to lie about that, then you think it's probably not true. His extensive testimony and the evidence cannot be considered at this stage of the proceedings at all. I think they're missing the mark here. I'm waiting to see if they're going to get to the argument about the law. I'm fine with them not having to review the lower facts. I think the facts are clear on what the record says, but it's about the application of the law. Now, other evidence in the eyes of this court was either vague, marginal evidentiary value. Simply put, there's not sufficient evidence that the expenses were not roughly divided evenly, or that the DA was or as currently remains greatly or pecuniarily interested. And so there's not enough evidence here, but the evidence that actually does remain for consideration makes it clear, says Fani. We talked about travel and meal expenses, and the court's frank appraisal of her testimony was that it withstood scrutiny. The trial court allowed the defense to pull together everything they could, and they were even less successful with their suggestion that Fani might have initiated this case just to hire Wade. And so there was no adequate showing that there were financial arrangements here. And when the trial court's findings are considered in light most favorable to its order, the theory of conflict has no factual basis remaining. To the standards that McAfee applied. But if there's a different standard of law that the Court of Appeals dictates, then the interpretation could change. So at this stage, it's like the rules change. At this stage of the proceedings regarding the alleged presence of an actual and disqualifying conflict, the trial court accepted Fani's lies about how she and Wade split her costs, the manner of the case, and Bradley's credibility as it disintegrated on the stand, who was Fani and Nathan's friend. Then they changed. They pivoted from financial concerns to now the timing of the relationship. Well, that's because they perjured themselves. So yeah, they also lied in their affidavit, and the relationship clearly started before they said it did. They lied to the court about that. So that's why the strategy changed, because they lied. But any concerns held by the trial court were dispelled because McAfee was trying to save his butt for re-election. The trial court crafted this remedy squarely within its inherent powers, and the assessment of the facts had not negatively impacted Trump's rights at all. Said that Fani got no material benefit from the relationships, and it was only that there were questions from the continued presence in the case. And so since he's no longer on the case, there is no longer a continued presence. And so the extensive review of her public comments says Fani did nothing wrong. The only statements the trial court examined in greater detail were about the speech on January 14th, but said it did not cross the line because they didn't use the defendants' names. And so this entire appeal should be nuked. And as the trial court has efficiently described in other orders, there's no basis for reversal. So this appeal must be dismissed as being improvidently granted. So for the reasons above, we say this court should grant this motion to dismiss this appeal and let this case get back on track. From F. McDonald Wakeford, Fani's newest little minion over there, since the others have apparently abandoned ship on this case. So F. McDonald Wakeford sends that one in. And Fani is trying to get the Court of Appeals to unaccept the appeal, basically. So it's already been accepted. We're getting appellate memorandums drafted from the defense. And Fani say, undo that. Just reject it. which they're not going to do. Nice try, Fani. They're not going to appreciate this either. Improvidently granted, they're going to, we know what we accepted. Okay. How about you get the heck out of here? So that is from Fani Willis. Now, the man that she hired, who was extremely competent, very qualified, absolutely not anybody who she hired because she wanted his hot dog or Nathan's hot dog. She worked very hard with him to investigate this claim. He billed $700,000 worth of legal expenses. They traveled all over the world, smashing their heads together to come up with new strategies, legal strategies to get Trump. And Nathan Wade took a little time off to go and not support his ex-wife and kids. And now he's on with CNN and he's having a rough time. Fani Willis showing us who she hired. Here's how it sounds.
What is your current relationship with the district? Let's
turn this volume up a bit.
Attorney.
Just as outlined earlier, we are great friends. We speak regularly. The conversation has changed, though. Whereas before, our conversations were about this case. I'm sure you could imagine and appreciate the amount of time that it takes that you have to pour into a case a case of this magnitude, trying to prosecute those defendants. But our conversations have shifted to how are you handling the threats that are coming your way? Are you being safe? Democracy, the case will live on, kind of thing.
Just to clarify, when did the romantic relationship between the two of you start?
2019.
Yeah, so we get into, there's been this effort to say that, okay, these exact dates are at issue, and these exact dates are, I'm getting signaled here.
Signaled? What?
No.
Yeah, take it. You want to go off mic for a second?
Yes.
Okay. Go off mic for a second.
Keep rolling?
Yeah, keep rolling. Don't stop down there. Stay as speed.
Okay. Media guy or lawyer? Huh. Yeah, keep rolling. Okay, so the question was, when did the relationship start? We know it was 2019. We know they lied to us and said it was 2022 when they submitted an affidavit. So you better be careful on these dates there, Nathan, because you might have committed perjury. So don't incriminate yourself. Try again.
Okay, we're good. Good. We asked.
Everything okay?
Yeah.
Just to revisit the question, it was to clarify when the romantic relationship started and when it ended.
Sure. So, I believe that the public has, through the testimony and other interviews, the public has a clear snapshot that this is clearly just a distraction. It is not a relevant issue in this case, and I think that we should be focusing on more of the facts and the indictment in the case.
Well, I ask because obviously it's still a pending matter. It's going to be before the Court of Appeals, and you talked about how proud you were of all the work that you did in this office.
So he needed to go get some coaching to not answer the question. I think you've already had enough. This was a good snapshot. It's just a distraction and move on. He needed coaching for that. He's a lawyer. He's a criminal defense attorney. Did he not recognize on his own that he was about to get hit with perjury? He was about to go in and start, dating's complicated, Kaitlyn. You know how these things go. I mean, sometimes you send a nice little text message. Next thing you know, before you know it, you're in the sack. It's like, hey, what? Wait, what? Shut up, Nathan, shut up. You don't know when it started. So just get back out there and don't answer the question.
And I think the question that people have when they hear from the Court of Appeals, this isn't happening until next spring, is did the relationship jeopardize that work that you did in this investigation?
Yeah. And therein lies the issue.
What?
Why we wouldn't touch upon the work of the Court of Appeals or some higher court, because it's a pending issue before them.
Oh, so you can't talk about it now?
Allow them, take a step back and allow them to take the evidence that they have and do their work, make the decision.
Right. But you did testify to this, and you were asked about, on the stand, about when it started and when it ended. It just wasn't completely clear, because before it said before the indictment, which was August 15th here in Atlanta, and then later the answer was at the end of that year. And so I think that was the clarity that people were seeking of when it started and when it ended.
Sure. And there again, there's a question before the court. And that is the crux of the question. I don't choose to say or do anything that would jeopardize the case or the court's ruling. I prefer to allow them to make their decision based upon what they have and accept it.
Do you believe, as you reflect on this, that your relationship with the district attorney was a mistake?
Absolutely not. Absolutely not. What I believe is this whole conversation is a distraction.
Loved each other.
That's all. It's a tool to stop the train, to slow down the inevitable, which is the trial of the defendants named in the election interference case.
Of course, there's no regrets here. Are you kidding me? Dude got 700 grand, was taking Fani to Willis land repeatedly. He was like coasting for 3 years. Are you kidding? Coasting. He's like, yeah, I'll go visit the White House counsel's office. Yeah, I'm doing tons of work. Yeah, I'm going to build this. He built 24 hours in a day. Not even a single pee break. Not even one. He's having a good time, man. He lost his wife. He's like, gosh, I was so sick of her anyways. 20 years of her. Josh, get out of here. So he got rid of her. He disowned his 2 kids. He's like, hey, good luck in Spain, daughter. You're not coming home. Figure out your own trip. Sorry, son. No more new car for you. Or whatever the things were. He disowned them. Now he's got a new Audi. He's got nice new suits. He's got 700 grand in the bank. He just finished pounding out Fani for 3 years. And now he's on CNN. He'll probably write a book about it. This is the best thing that ever happened to him. All right. So that's Nathan Wade. And man, what was that? Is he even a real lawyer? Does he even know how to talk at all, or know perjury rules, or have any concern for his well-being at all? It was pretty bad. All right. So we'll see what happens. Now, Steve Sadow and the defense team are going to have a lot of fun with this, because it's kind of ridiculous. Like Fani, you're going to ask them to reverse they just accepted it. You're going to ask them to reverse themselves. We'll see if that happens. I doubt it. But Steve Sadow, the defense team, Ashley Merchant for Mike Roman, the rest of them will be filing their responses and their appellate memos at a date coming soon. We'll be here ready to cover it. So thanks for subscribing, my friends, wherever it is you're watching this. And if you like this video, we'd love it if you liked this video and stuck around for the next video that's coming up, because we're going to be talking about Congress, and they're taking some action to stop what's happening against Trump from the various state prosecutors like Fani Willis. What can they do? Can they maybe remove these cases from Fani's jurisdiction and take them up into federal court? Congress is trying to do that. We'll talk about how it's done right here on the next video, which we're getting to right now. So let's talk about it, because we got one final segment on the day, and here is what it looks like. House Republicans finally moving forward to do something about these state-level prosecutions. Tish James in New York, Alvin Bragg with his criminal prosecution, Fani Willis, and there will be more, no doubt about it. They have a plan, which would be to remove the cases from the state, bring them up to federal court, so we don't have as rigged jurisdictions as we've got now. We're going to take a look at the bill. It's a short one, along with this montage from the Democrats showing how they've orchestrated all of these political lawfare onslaughts before we see what's happening in Congress. Because remember, in the Bragg prosecution, they made the argument that Trump had a conspiracy to violate federal election law and so on and so forth. But then they didn't actually charge him with federal election law violations because the feds investigated it and declined. And they didn't define what the object or the predicate offense was at all, so that the jurors could just kind of make it up. Well, the FEC expert was testifying in Congress, giving us some real clarity on why this was such a rigged verdict. But the GOP were the people that flagged this for us. This is the new bill that Congress is shoving through, and it made its way out of committee today. You see, the GOP wrote this. Did you know Manhattan District Judge Juan Mercan's decisions, guided by political bias, unfairly prejudiced the outcome of the trial, and they ensured Trump did not get a fair trial. Just before the trial, Mercan placed gag orders on Trump, which we covered, and they prohibited him from engaging in political speech. Now, during the trial, Mercan routinely allowed inadmissible evidence into the record against Trump, prevented Trump from introducing key evidence, and at the end of the trial, Mercan also refused to provide the juries with a written copy of the 55 pages of confusing jury instructions. And so now, this is a prime example of why our committee has passed H.R. 2553, the No More Political Prosecutions Act, to allow a former president to remove a state trial to federal court, so that the Bragg case would have been moved up, and the Fani case would see the same fate. Now, whether they're going to get a better jurisdiction in federal court is questionable. That's debatable as well. We know that there have been some very biased judges against Trump in the Southern District of New York, for example. So if he pulled the Bragg case up to the SDNY, would it be any better? I don't know. He could also get Judge Kaplan, which was the same judge in the E. Jean Carroll case. So something like that could be a big problem. But let's think about in Georgia, right? Now, getting out of Fulton County and going up to federal court in Georgia would very much expand the juror base and be very useful to Trump in that regard. So you can see why it would matter and why it might be useful. Here is what the bill looks like. Very short. You can see it's H.R. 2553, to amend Title 28, saying this has been introduced by a bunch of people, you know, Van Drew, Moore, Fitzgerald, Niels, Biggs, Hageman, Boebert, Miller, Johnson, and Donalds. Byron Donalds also submitting this one. So here's what it says. The bill is to amend Title 28 U.S. Code to authorize removal of an action. And when we take something from a state court to a federal court, we call it removing it from state court into federal court. So if you're prosecuting a president, a vice president, former vice president, that's what happens. So very, very simple. It says here, this is all it's going to do. In general, Section 1442A is amended in paragraph 3 by striking the semicolon and inserting this by adding at the end the following: the president or vice president or a former president or vice president. So it's just amending the removal statutes of the legal procedure. The amendment made by the subsection shall apply to civil actions or criminal prosecutions pending on the date of the enactment. Pending on the date. Yeah, so it would apply to Trump if this passed today, or commenced on or after such date. So as long as the Trump cases are open, this would apply. So if it's closed, you can no longer remove them. So let's say this passes, or let's say even this gets carried over into the next Congress. So we have the 2024 elections, Trump wins, Congress is kept by the Republicans. Maybe they win the Senate back, something happens. Then they could pass this. And if the Fani trial is still ongoing, then they would be able to remove that one into federal court. That would expand the juror pool from the Fulton County up into the entire state of Georgia, which might even vote for Trump this year. I think it will. I think he's up dramatically in the polls there by 5-6 points. So that would be good. I think it's a smart strategy for the Republicans to be pursuing this, and we'll see if they ultimately have the votes to push it through. But why is this necessary? Well, this was a nice montage summarizing all of the political attacks that this one also came out from the House Judiciary GOP. This is why they're releasing this, because of this never-ending onslaught of Democrat lawfare.
We just have to demonstrate that he will not take power if he does run, making sure he, under legitimate efforts of our Constitution, does not become the next president again.
In order to make America great and glorious again, I am tonight announcing my candidacy for President of the United States.
Based on recent developments, including the former president's announcement that he is a candidate for president in the next election, and the sitting president's stated intention to be a candidate as well, I have concluded that it is in the public interest to appoint a special counsel.
Illegally.
Today, I signed an order appointing Jack
Illegally.
Smith to serve as special counsel.
Yes,
also the lowest learner, you know, he was giving advice to perhaps go after conservative groups for IRS matters.
And so, you know, what I get out of that is I think he's been overzealous in some of these low-profile cases. He's willing to stretch the law. John Roberts called it a boundless interpretation that would catch up politicians in their ordinary acts that they do for people. And I think it's just says maybe a lack of judgment. And that's the concern that I get out of my case and the others.
The White House fired back after defense attorney Ashley Merchant testified yesterday about a meeting between District Attorney Fani Willis and Vice President Kamala Harris. Merchant cited evidence that Willis visited the White House in February of 2023. That's just months before a grand jury in Georgia indicted President Trump in the state's election interference case.
America is an uncharted territory. We are angrier and more deeply divided than we've ever been at any point in our history.
Here it comes.
Since the Civil War. I'm running for Attorney General because I will never be afraid to challenge this illegitimate president.
Yes!
When our fundamental rights are at stake.
But decided to pursue this one. And when he did, an interesting attorney came on board late in this whole process, Matthew Colangelo. Tell us why we should know about Colangelo's role in all of this.
Because he held the number 3 spot at DOJ, which is maybe the most coveted spot at the Department of Justice outside of Attorney General itself, because typically that job is a straight path to becoming a corporate bigwig, making a lot of money. It's considered very elite. So for him to step down from that, to go work for a local prosecutor in New York on this case, it says something. I think it says that he's got to be a pretty true believer, and this is personal, if he wants to get involved in this.
I'm the candidate in the race who has the experience with Donald Trump. I was the chief deputy in the Attorney General's office. We sued the Trump administration over 100 times for the Muslim travel ban, for family separation at the border, for shenanigans with the census. So I know how to litigate with him. I also led the team that did the Trump Foundation case. So I'm ready to go wherever the facts take me and to inherit that case. And I think, you know, it'd be hard to argue with the fact that that'd be the most important, most high profile case. And I've seen him up front and seen the lawlessness that he can do. So I've seen a pattern of lawlessness over 20 years. And so I'm inclined to believe all I see in the public domain and know that there's, and believe that there's a path forward there to make a case.
Good ad. Of course, that is what we're witnessing. We've been covering all of those prosecutions. Face twitch Tish spasming out over her TDS. Hopefully she's got something for that now. But it's never ending. They're running for office. They get elected to deliver on their campaign promises, and they do. And Colangelo left one of the most prestigious positions on the whole planet to go work for Bragg to be a part of it. Why is that? Well, we know why. Because he's part of a conspiracy, a political operation to take out Trump. Someone else who's a part of that is this guy called Norm Eisen. And he was getting questioned pretty good here by this fella. The Oversight Committee, the House Judiciary Committee, rather, is sharing this video, watching Representative Tiffany lace into Norm Eisen. Norm Eisen, many people call a conspirator of anti-Trump operations, including the first impeachment against Trump, and a lot of other onslaughts, like the creation of Michael Cohen to create other lies against Trump. So here is this exchange from testimony in Congress today.
Sure, you answered the ranking member, I think, and I want to make sure I heard it correctly, that you said President Trump's interference in the 2016 election.
Correct.
Is that correct?
That's correct.
Talking about the Bragg
interfered
case.
in the 2016 election.
Yes, sir.
And real quickly, how so?
The jury unanimously found in the Manhattan case that former President Trump had committed 34 felony violations of document falsification.
You weren't referring to anything else?
No, that's not true. That's disinformation, sir.
Yeah, okay.
In order to find that, they were charged with election interference. The underlying crime that made that a felony, not a misdemeanor, was election interference. Same pattern as 2020.
So it's all about election interference in 2016 also. Ms. Foley, so we heard from the gentleman that's to your right that he said that the DOJ should be viewed as above reproach because, look, they prosecuted the president's son. A year ago, weren't they cutting the sweetheart deal? Do you recall the details of that?
It was non-prosecution
Yeah, I mean,
agreement,
they were basically just going to let him walk. For all of them. They already allowed statutes of limitations to expire on multiple more serious felonies.
So how did that happen that we actually may get justice in that case?
A little bit.
Well, I mean, look.
Wasn't it the judge that threw out the sweetheart deal?
Yeah, I mean, you had a judge in Delaware that threw out the sweetheart deal.
Biden threw it out.
You know, I guess
The
there
judge
was
just
egg
caught
on the Biden administration's face, so they felt like they had to do something.
Yeah,
so they
did.
pursued these current charges, the gun charges and the tax charges.
Which were also the rigged charges. They
but, you know, I mean, did they reach the right result? I assume so. I didn't follow that trial very much. I think there'll be an interesting question as to whether the president commutes his son's sentence. So we'll see.
Which is, So, also, the gentleman next to you referred to under questioning, he said this trial and jury was scrupulously fair. It was outstanding. There was nothing unusual. Care to comment on that?
Well, again, I mean,
you could start with nothing
I'm not
unusual.
blaming the jury here. I think the poison came from the behavior of the prosecutors hiding the ball.
And the judge.
And then Judge Mershon giving sort of a cafeteria-style approach where non-unanimity was allowed on the
I like that.
underlying,
Yeah, we said buffet.
means by which the New York election
Or
law
pick a
was
card, any
violated.
card.
I
Pick
think
a crime,
those are
any
clear
crime.
due process violations. So it's not the jury's fault. They just had, junk to work with, so to speak. I was going to use
They
another
had a cafeteria
word, but,
tray.
I probably shouldn't.
Yeah, some of that, some of
It's
that.
almost
some of
enough
that.
to shock the conscience, huh?
It's almost enough. Yeah, it shocks mine. I don't know about yours, but
I believe it's correct, and I can be corrected on this if I'm wrong, but I believe the judge contributed to President Biden, the judge
Yeah, you're
in this
not wrong.
case.
No, $35.
Is that common
Two
for a
separate
case that
payments.
has a real nexus that the judge would contribute and then not recuse?
I've never seen a case like that. I mean, usually a lawyer feels pretty confident if he finds out that the judge has overtly, expressed preference for one party or another, and political contributions to the Biden administration would seem to fit that bill, given the political overtones of this case, right? This was not an ordinary state prosecution. This was a state prosecution that, if successful, even though it had been turned down at every other level to even proceed as a prosecution.
That's right.
If it proved
By
successful,
Manhattan.
it would basically interfere with the 2024 presidential election. And
By design.
possibly that interference could not be remedied, could not be rectified until after the election. So it's slam dunk 2024 election interference.
Happening right now.
It's almost reminiscent of Jack Smith and Governor McDonnell in Virginia, isn't it?
When he was running.
And he got his, handed to him by
Yeah.
the Supreme Court on that one.
I want to get a question into Attorney General Bailey here. Talk about the overall chilling effect in regards to this. In fact, I believe it was Governor Hochul after this charge happened, went on media in New York and said, "Hey, don't worry. This isn't going. We're not coming after the rest of you business people. This is just Donald Trump." Talk about the impact of something like this for the long run in the rule of law.
The Constitution is our national identity. Those rights codified therein come from God, not man, and the document is intended to protect us from the government. And yet what we see time and time again is the government being weaponized against individuals. It's President Trump today. Who will it be tomorrow? And that's the problem. I think that when you look at the due process issues contained in the charging document, ultimately in the jury instructions, you look at the inchoate nature of the offenses with these ill-defined levels of attenuation. It's as if invisible links of chain are necessary to connect the facts to criminal liability.
Whatever they want.
And it causes the jury to turn into a roving commission, free to pursue whatever facts they want to attach liability as they please. And the issue there is it undermines the rule of law for the rest of us. Who can have confidence that we know what is and isn't illegal behavior when the court and the prosecutor impanel a roving commission to attack a political opponent?
Yeah, right on. Amen. Good stuff from those witnesses, except that first guy, Norm, who is just a strange fella. But elsewhere was this testimony from this individual. FEC commissioner was testifying right next door in between the two of them. And we'll listen to his opening statement because this guy is going to explain why this whole 2016 election interference narrative is insane. FEC already looked into it. They declined. And Bragg tried to create a federal crime to make it an object offense of a misdemeanor, to turn a misdemeanor into a felony, even though it was a non-charged offense, or not even, it was rejected because there's no evidence of it. So it was allowed, and let's watch this obliteration occur.
It's an honor to appear before you today to discuss the critical issue of jurisdictional overreach in the prosecution of federal campaign finance law, specifically regarding the actions of Alvin Bragg, the district attorney for Manhattan, in his prosecution of former President Donald Trump. No less critical, I want to highlight the inaction by the Department of Justice to defend federal jurisdiction in this case. The Federal Election Campaign Act serves as the bedrock for regulating money in our elections. It delineates the authorities responsible for enforcing these rules, vesting exclusive jurisdiction in the Federal Election Commission and the Department of Justice. This statutory framework is designed to ensure a uniform application of campaign finance laws nationwide, preventing the creation of fragmented enforcement landscape and leveraging the expertise and resources of federal agencies. District Attorney Alvin Bragg's decision to pursue charges against former President Trump for alleged violations of federal campaign finance laws marks a significant deviation from this established legal framework.
Yep.
By doing so, Bragg has effectively usurped the jurisdiction that this Congress has explicitly reserved for federal authorities.
Right, it's the Fed.
This overreach sets a troubling precedent for the politicization
don't care. They
of
wanted
legal
it.
proceedings at the state level.
They couldn't do it.
The
so they let
danger
him.
here lies in the disparate enforcement standards that torture well-established federal law processes. As an example, the state judge in New York misinterpreted federal criminal mental intent standards and gave the jury an instruction which read willfully contributing campaign contributions, but the statutory mental intent found in the Federal Election Campaign Act is knowing and willful. Now, imagine 50 states enacting the crime of campaigning by unlawful means, and 1,000 different state and local prosecutors prosecuting presidents, former presidents, presidential candidates, and any number of House and Senate candidates under varying interpretations of FECA by bootstrapping those laws through their state's unlawful means criminal code.
Right.
It is also disturbing in this
Hopefully some
case what
Republicans
hasn't
do it.
happened over at the Department of Justice. Given the clear precedent established by the U.S. Supreme Court regarding the prohibition of state officers prosecuting federal crimes, it is perplexing that Attorney General Merrick Garland and the Department of Justice did not intervene in the prosecution of Donald Trump.
To reclaim
the
their
DOJ's election year
jurisdiction.
sensitivity policy is designed to protect the public from being influenced by legal proceedings during an election year. Had the DOJ zealously represented the United States by intervening to protect its own jurisdiction and that of the FEC, this issue might not be the predominant one of the 2024 presidential cycle. A disclosure on May 31st in unredacted FEC documents reveals that the Department of Justice conducted a year-long investigation and found no criminal acts committed by former President Trump. This revelation underscores the problematic nature of Bragg's prosecution and his intrusion upon federal jurisdiction. Again, the implications for allowing local district attorneys to prosecute based on their interpretations of federal campaign finance law are profound. Such actions risk eroding the uniformity and predictability that FECA aims to provide. For me, a larger First Amendment concern is at play here. That is the deterrent that this encroachment on federal jurisdiction will have on well-qualified candidates from seeking public office. Fearing disparate legal standards based upon their locality, preserving the centralized enforcement mechanism envisioned in FECA is essential to a fair and impartial oversight of campaign finance regulations and of our elections. Alvin Bragg's misguided prosecution of former President Donald Trump represents a clear usurpation of federal jurisdiction. Coupled with the DOJ's inaction, it's compounded the issue. The dangerous precedent of local prosecutorial overreach in matters of federal concern must be addressed to maintain the integrity of our electoral system. We must reaffirm the exclusive authority of the FEC and the Department of Justice to enforce federal campaign finance laws, ensuring consistent and impartial application across the United States. Thank you, Mr. Chairman, for the opportunity, and I look forward to your questions.
All right, good stuff. So the idea being that different agencies elbow each other to maintain their jurisdiction. You've seen it in the movies. Local cops show up to the crime scene. They're like, I hope those feds don't show up. Then the feds show up. They're like, it's our jurisdiction now. And Bruce Willis is like, not over my dead body it is. And, you know, that thing kind of happens. So that's normally what happens, but not when you're waging political lawfare against your opponents. Then what you do is you just kind of let everybody break the rules, and you don't really care about stuff as long as the ends are leading towards the outcome. The means lead towards the ends that you want. And in this case, it's the elimination of Trump. So what they have done is sent over Biden's number 3, Matthew Colangelo, from the DOJ, which will make enforcement decisions at the federal level. His number 3 goes over to Colangelo's, resurrects the Alvin Bragg case using the federal theory that he couldn't have brought in the federal courts because he probably wouldn't have been able to get it past a federal judge or to obtain a federal conviction. So they then parlayed it off back over to Bragg. Bragg was too squeamish and a little weenie to do it himself. I don't know how to do this. So then he brought in Colangelo and they did the whole thing together. And now the judge didn't let the jurors hear any about that. Wouldn't it have been nice if the jurors got to hear that the feds already investigated this election conspiracy nonsense and found that it was not valid? Would have been good, but it might have resulted in Trump being acquitted, which of course could not happen in an engineered, rigged verdict. So we'll see what Congress does with this. Likelihood this gets passed by this Congress and this Senate, low, but the theory is that these cases will still be ongoing after the election and Trump and co. can reinstitute it and maybe even pass it and bring these state prosecutions to federal court so that they are not brought by weaponized, partisan, lying, cheating, stealing hacks like Fani and Tish and Bragg. We're going to be here continuing to cover this, my friends. If you liked this video, would love it if you liked this video. If you enjoyed it, a subscribe would be even better. We'd really appreciate it if you shared it with a friend or family member so that they could also see what's happening in our government around us. We got other great segments coming up. We're going to send you over to this video, which you're going to love even more than this one. And we can't wait to see you over there. All right, my friends, that is it for us on the day. We covered 3 good segments. House GOP finally moving to do something about these prosecutions. Nathan Wade having a little bit of a meltdown in a bizarre interview. And Jack Smith has got to go, man. He's illegal. Sorry, Jack. You're not properly appointed. And it's time for you to hit the exits. But now, my friends, it's time to hear from you. And we'll see what you say about all this. Of course, if you haven't already gotten your ticket for our Watcher meetup, we're meeting up in just a few short weeks, June 29th. Get your tickets, watcherlodge.com, Trump Hotel, Las Vegas. We're going to be meeting there. The full schedule's over there. And check it out. It's going to be a lot of fun. So grab your tickets. We're getting all the food situated, getting the agenda finalized. We'd love to see you, love to meet you. Come hang out with some fellow watchers for a day of fun. Watcher Community Meetup, Trump Hotel, Las Vegas. All right. We also now are going to go over to see what you have to say about this. Thank you so much for your amazing support, your contributions and comments. We have this one from Angel. What's up, Angel? Sent this one at the start of the day. Says, good afternoon from Gainesville, Georgia. What's up, Angel? Says, Trump 2024, stop child trafficking from the Satanists. Yeah, gosh, I know. That's a good thing to stand against. Good to see you, Angel. Thanks for that one. Hey, it's the Munkins is here, bringing in 10 new membos. Thank you, Tony Hay. Bringing in Krishan P., Aubrey Debbie. We got Ryan E's coming in, Randall J., Aaron S., Sue D is here, Ricky Digits, welcome, Sam JD, and Danny D, along with Billy R, all coming in, courtesy of Tony Hay Munkits. Thank you, Tony, for bringing in 10 new membos. B-Man on the YouTubes says, Nathan's handler from the party, also Mikey Cohen's lawyer, is Lanny Davis. And who did he work for? Lanny worked for the Clintons. Big time. Yeah, and Lanny Davis, and I'm pretty sure Norm Eisman, the guy we were just listening to in Congress, also had some Cohen involvement. But yeah, Nathan's I guess, Fani handler was there to make sure he kept his mouth clean. What's up, Unwokel? Says, Unwoke Thoughts posted a video on X of Fani Willis at a church complaining about people who call her Fani. That sounds awesome. We'll see if we can dig that one up, maybe for tomorrow. Well, that's her name. I don't know what her problem is. Okay, her name is Fani. And she is the biggest Fani in Georgia because she's the DA of Fulton County, obviously. Do you know anybody bigger than Fani Willis in Georgia? I don't. If I'm wrong, correct me on that. I'm happy to be corrected. She's the biggest Fani I know in Georgia, that's for sure. What's up? Charlie Wolf Reed is here. Says there are videos of Jack Smith's and Biden's crimes. Yeah, I'm sure that there are, because Joe Biden is just a walking crime. Hey, Joe B1 Kenobi says, a question for anyone not voting for Trump because they fear he's a dictator. Okay, even if that was true, it's not. How is that worse than voting for an unknown, unnamed cabal, alias named Joe Biden? Yeah, that is curious. That like they're very oppositional to Trump's a dictator. Okay, so you'd rather have somebody who is not even existing, I guess? Well, at least he's not a dictator. Well, you don't even know. Like, maybe he is. Maybe the people behind him are the like, wouldn't you rather have someone you know than someone you don't know? At least Trump left. Trump didn't prosecute any Democrats openly, volitionally, like is happening now. Good question. Spuds is here. Says Elbridge Jerry is the creator of gerrymander. That's a fun fact. Didn't know that one. What's up, Spuds? Thanks for that education. Hey, Pritchie says, hello, I'm back. Good to see you, Pritchie. Membo for 4 months. Good to see you, Pritchie. I know you were in the hospital for a while. Was a long recovery, but all clear and healthy. No more infection. Can't wait to see Smith's removal. I'm with you on that. That's going to be a good day. Hey, Pritchie, thanks for this. Bringing in 10 membos. Cyndia M coming in. Coffee's coming in. Little T's here. Carol Tatum. What's up? A harpist in Austin. Wow, that sounds cool. Harps are pretty cool. Motivational humor happiness. Grumpy Old Studios is here. Dan D. We got Crystal M. Zach B. got in. Loki Mischievous also joining us. All courtesy of our friend Pritchie. Great to see you, Pritchie. Thanks for bringing in the new membos. We got 5 more membos coming in, courtesy of Tony Hay Munkets. We got this one from Auntie Plode is here. Nicholas D's in the house. Jim's joining us. Space Baby and Rabbit Stick all coming in, courtesy of Tony Hay Munkets. Thank you, Tony, for the membos. Felix bringing in says a Biden 2024 is World War III through the USA UKR security agreement. Oh yeah, this today was a wild one. What's it, 50 billion more going over to Zelensky? I just saw those headlines as we were sitting down. Amazing. A loan. We're going to get a loan paid back from Zelensky. Give me a break. They think we're so dumb. I guess some parts of the country are. Hey, what's up, Philip B? Who gave you that hickey on your bicep? Yeah, kind of a weird spot for a hickey. It's a bruise from a little bit of jujitsu going on. Your boy's back on the mats again, getting my A beat. Yeah, hickey be a lot more fun. Actually, grappling's pretty fun. Yeah, but a hickey, not on the bicep. Hickeys are a different category. We'll just leave those two concepts completely separate. What's up, Felix? Says, Fulton County DEI Lawfare. Felix, DEI Lawfare in Fulton County. Yeah, it's happening all over the place, no doubt. Hey, Felix sent this one in. Biden 2024 Lawfare is fascism, no doubt. Hey, what's up? Chubby says, Fani isn't missing the mark on her filing. She's purposely avoiding it in order to try and confuse the Court of Appeals about what the actual issue is. She does the same thing every time she replies to congressional letters. She didn't even talk about the law at all or the standard of the law at all. She just talked about the facts. You can't contest our facts. We're not asking about the facts. We're asking about the conclusion and how the facts apply to the legal standard. So the conclusion will change based on the application of the standard. If the standard is different, it's going to have a different conclusion. But that's complicated for Fani. Felix says, what does odor of mendacity mean? I think it means a stench of lying, Fani. Big Fani lies from your big Fani mouth, says Felix. That's right. Odor of mendacity. Stinky, too. Chubby says, gotta love how Wade totes the Fani talking point line that she's constantly being threatened by Trump supporters. I'm actually surprised he also didn't say it's because she's a strong black woman doing God's work and everyone else against her are racist heathens. Yeah, that's a great, maybe next time. Maybe he's got to rehearse his script a little bit better. Oh, crap. Line. Racism. Just call them racist. Oh, that's right. White people are racist. Kaitlyn's like, yeah, that's true. That's true. Good to see you, Chubby. Voice of the People says, I love how Wade can remember during this interview, but as a case of CRS in court. He actually couldn't remember during the interview. He's like, oh, crap. What do I say? It actually maybe lent him. He's like, I don't remember. I have no idea. I don't know what the hell's going on. I don't even know where I am right now. My IQ is about 16, room temperature. So, yeah, I don't know. It's funny, right? And then he remembers. That's a good point, Voice. That's a funny comment. Selective memory, indeed. Knox says, happy Thursday, all. Has Nathan always been such a poor public speaker, or is it just all the lying? Yeah, it's tough to tell at this point now. We've seen him a couple times in court, but not anything substantive. And we saw him testify, and it was terrible. And this little interview was terrible. So he might just be totally incompetent, and Fani just wanted the hot dog. Sheila P., what's up, says he can't be trusted to answer interview questions, but he was so qualified to be appointed to a case of national importance. Crazy. Yeah. Well, we know why he got appointed. They had cruises to go on. Knox is sharing this one. Yeah, this is the moment that Joe Biden wandered off. You guys see that clip? Joe Biden wandering off into oblivion. President's totally gone. Good to see you, Knox. Nitty Linny says Fani got all defensive because she and her man were being questioned. She never understood that it's not about romance. It's about the law, ethics, and lying under oath. She proves our point for us. Yeah, that's exactly what we were saying at the beginning. Like, if Fani had any integrity at all, she'd just say, okay, look, yeah, I kind of think that would happen maybe 20 years ago. Yeah, people would be shamed. People get shamed into, because they did shameful things and illegal things. And they cared about that. Now everybody's a victim of everything. You did something monstrous and heinous, and you stole money, and you wrecked a marriage and all sorts of stuff. And you lied to your constituents about it. Then you lied to the court about it. Then you coerced a witness to lie about it. And they're the victims this entire time. And probably write a book about it. What's up? Let's go, Brandon. Membo for 13 months. Is Fani taking Chestnut's spot in July at the hot dog eating contest? Yeah, apparently this person, Chestnuts, is not going to be participating at the hot dog eating contest. But since Fani has a lot of experience with Nathan's hot dogs, maybe she can go there. Great resume. Yeah, a lot of experience there for like 2 years, 3 years. So a lot of experience. Hey, what's up? Sheila P. bringing in 10 new membos. Ray T. coming in. We got Jeff H. is here. Tubby B. What's up? Rita, Ricky, Nikki G. What's up? Fun Size is here. The one and only Joe. Golden Gaming saying shout out. Leisha L. Jacob H. and Cynthia J. gifted membos courtesy of Sheila P. Thank you, Sheila, for bringing in 10 amazing new membos. Voice of the People says, don't like the act. Say Biden gets charged after office. He goes to the federal with a crap system. Remember the SEAL Team 6 question? They can do it then. Yeah, so you're right. Both sides would get it. So Biden he would be removing it. Yeah, I guess that's a fair point. It's like, why would Republicans fix this now? Shouldn't the Republicans use it? Like, don't pass this and then just win. I think that's a better strategy, Voice. I think that's a great point. Yeah, no. We want loads of state prosecutions of Democrats. Are you kidding? They broke the seal. We're going to actually, okay, maybe they invented it, but we're going to maximize this. Like, the Republicans are the capitalists here. Okay, let's take this to full effect. And once Trump wins the White House and we have the Senate and the House, we're going to want to obliterate the crap out of them with lawful political prosecutions. Just like they did. I like it. What's up? Sheila P. says, they just needed to add the statement, show me the man, I'll show you the crime, or I'll create it. Yeah, great phrase. Show me the man, I'll show you the crime. And there's another one. For my friends, everything. For my enemies, the law, right? Sean Lively, what's up? Hey, Sean, thanks for being a membo, bringing in 10 new membos. Blah got one. Hypnosis Fairy's here. Denzel M. Akbar's here. Tia T. We got Timothy B. Reformed Convict is here. Jason T. Randy V. Death's API. Wow. And Animal Farm all shouting out and welcoming our newest membos courtesy of Sean L. bringing in new membos. Even more membos from Dolphin Fan is the man. We got Aubin Ann coming in. Fishing NorCal. Sizzlin Honeybee, WL's here, Dire Gnome, Scott. We got Daryl B, Spacetime Continuum is here. Wow. Chuck Cook, Heather F, all gifted membos, Dolphin Fan, always the man in the house. Thank you, Dolphin. What's up, Flash River says, Rob, Representative Thomas Massey highlights that Congress's hush money payments would be considered campaign finance violations under Alvin Bragg's novel theory used to target Trump, and Representative Massey responds. Yeah, Congress has like this sexual settlement slush fund. The irony here is that this trial was all about trying to influence the 2024 election, whereas all these Congress hush money payments are the same thing. Good comment, Flash. Waldo says, 5 new members are coming in. Tom H. We got Ian M. Findlay V. Dwayne J. in the house. And Suze Mad. Gifted members courtesy of Waldo. Great to see you, Waldo. Thanks for doing that. Hey, Felix is here. Bringing in, says Biden 2024 lawfare is fascism. Good to see you, Felix. That is true. That is a true statement. Hey, what's up, Neo Shazam? Hey, cool. Just ordered from the Wellness Company with your code. That's awesome. You're going to be getting a nice big kit of all of your medical goodies coming soon. Links in the description below. Thanks for supporting our sponsors, my friends. It means a lot to our continued work together. And you're going to get some good stuff too. So check them out, the Wellness Company, down below. Code Robert at checkout. Hey, Chubby says, I'm really curious to know if FECA sent any letters to Garland regarding the jurisdictional issue. Yeah, something like that would be immensely difficult to defend ignoring. Good question. Yeah, good question. I don't know if any federal prosecutors were wanting to reassert their dominance or not, but I doubt it. They're probably, they knew that they couldn't do it themselves, so they just let Bragg do it. Amazing. Iconic Meerkat says, please leave your touch DNA on that like button. That thumb DNA. Just, hit it. Or that's one with the mouse button. What's up, Iconic? Madeline J in the house, sending in a very nice thumbs up. Thank you, Madeline. Thumbs up right back at you. Appreciate you being a membo and supporting us here today. Hey, Jennifer says, another great show, Rob. Getting excited for Vegas, baby. Oh, man. Jennifer, you're coming. It's going to be so great. Thanks for your time and all your hard work. Thank you, Jennifer. Chuck says, I require a 6-foot social distance? No, not at all. We're giving, big hugs and fist bumps and all the things. We're going to bro it out in Vegas. So come check it out. Jennifer, can't wait to see you. Thanks for being a membo. Thanks for being so supportive. It's going to be fun. Get your tickets. WatcherLodge.com. What's up? Salty Sarge on Rumble says, poor Fani. After illegally funneling nearly $1 million to Wade and his law firm, she ends up with a gigolo who is shooting pool with rope, which doesn't make, I don't know what that means. I hope he can do close-up magic or shadow puppets. I don't know what I just read, and hopefully I don't get canceled for whatever that means. Thank you, Salty. Hey, Stephen M. says DEI Olympics. They're hurtling over each other, and Nathan Wade is winning at the head of the DEI pack. What's up, Ziggy Girl on Rumble? Thank you, Ziggy Girl. Very nice dono. Says, the more we learn about lawfare, the more we will be able to defend ourselves against their lawfare against us. Thank you, President Trump, and thank you, Robert. Such an astute comment, Ziggy, because without President Trump, I don't think we would see this. Like, these people exist. They're political monsters and political cheaters and bullies and liars. They've always been in the government. We just haven't really known it. Now that Trump has emerged, he's drawing out all of these creatures from the depths. And we get to see it on full display. And it's a disgusting sight. It's pretty traumatic and chaotic to recognize that we lived with this infesting our body politic. But now that we know they're there, we can do something about it. And so I agree with you. Thanks to Trump. Honestly, I don't know if there's anybody else who has the stamina to deal with something like this, but he is, and we are grateful for it because I think he's drawing out stuff that we need to see, even if it is rough. What's up, Jay Water? Roadless Wolf says, evening, y'all. Just caught up on this live. 2x speed makes the show more entertaining. Because I'm talking like a chipmunk, man. You're getting legal content at twice the speed? We can't do it, Captain. Hey, what's up? The Rubos say, thank you, Rob, for all you do keeping us updated and informed. The most entertaining and best live stream on the internet for sure. Well, I don't know about that, the Rubos, but it's a nice compliment. Thanks for that. May God continuously shower you and the Watcher family with blessings. Amazing. The Rubos, thank you for that. And the Rubos have some of the best prayers you've ever seen and the best salt you've ever seen at rubosaltshop.com. Oh, it's good stuff. I don't know what kind of salt you're using, but it's time to upgrade it. Check them out. The Rubos are amazing, and they also sent in a tip. Thank you, the Rubos. Last message was supposed to post with the dono. We got you, the Rubos. We love you guys. Thanks for being here. And blessings to all of us. Amen from the Rubos. Thank you, guys. Whoa, what's up, Beth Coddington? Farmer's daughter's in the house. Beth Coddington, very nice to see you, Beth. What a lovely surprise. We got 20 new membos coming in, courtesy of Beth. We got Rhoda B. Kim A's in the house. Melissa's coming in. American Dreamer. We got Roland R. Pip is here. Hooray. Bernard Sweeney. We got John S. We got T. Ross. What's up, Monty M? Pamela B's coming in. Don M. Tom L. Robin M. D. Don A. Frosted Sleet. Andrea P. Justin T. America First. All in the house, along with Denise K. Gifted membos, courtesy of our friend Beth Coddington in the house, aka Farmer's Daughter. Good to see you, Beth. Thanks for being here and for gifting 20 new membos. Bobsco's in the house, bringing in Chris H. Welcome aboard, Chris H. And thank you, Bobsco, for the invite. And Salty Sarge in the house on Rumble saying, after Obama's re-election at the SEIU event, Obama stated on video, now that we have won re-election, it is time to reward our friends and punish our enemies. That tells you all you need to know about the Democrats. Good to see you, Salty. Yeah, there are Democrats first, countries like a distant fourth or fifth. They don't even care. Constitution, all that stuff? No. Yeah, what? We have to talk about climate change and pronouns. We can't let a pesky Constitution get in the way of that. What's up, Husky Mom? Says, shout out to all the great folks over on YouTube. I spent the show over there with some very fine people. Indeed. Amazing. So we have cross-pollination happening here. Locals friends, meeting YouTube friends, Rumbles friends, saying hello. It's just one big, giant, happy family. We love everybody. It's so good to have everybody here. Let's get out the guitar and sing Kumbaya together, shall we? Let's say hello to Twitter. Let's say hello to Twitter and bring them into the party with us. Okay, here it is. Let's see. Oh, we posted a ton of our shorts, like 15 of them, because we were a little bit backed up on those. All right, so where's the live panel? Probably not going to have a lot of comments here today. Let's see what we got cooking. Hey, what's up, Christina? Danny McWilliams. Hey, what's up, Shakes? Hey, Shakes. Oh, hilarious. Okay. Hey, check this out. Shakes is healing up rapidly as we speak. Says, thanks, Rob. Great show. Says, the Constitution is awesome. We'd have anarchy if we didn't have it. Says, I'm in a boot right now, but it's too big because my leg has shrunk. But I have to gripe about it right now. So here it is, healing up with a boot while we're praying for a speedy recovery over there to you, Shakes. Thanks for sharing it. Thanks for watching the show. Hopefully, we're going to send some mitochondrial energy into there to heal up those bones. All right, good to see you, Shakes. Thanks for that. Hey, Christina H., what's up? What do you want to bet that this cat Wade will end up with some tax fraud thing? Glad to see the Constitution started to making a comeback. What authority can Biden enter into any agreement with Ukraine when he's not even competent mentally? Good question. Hey, what's up, Danny says, if Trump does not win, we're screwed. And Robert, you'll be in jail. That's probably true. I've thought about that. Yeah, I've thought actually about this. Like, oh gosh, what are they going to get me for? What are they going to get me for? I don't know. Some sort of misinformation, illegal memes. One of my jokes will throw me right in jail. Like, I was kidding about that. They're like, so you could have murdered 50 million Americans with that joke. Oh God, here we go. I'll go in there. What's up, Steve? Hey, what's up, Peter? How you guys doing? Garrett Ziegler will be in there with us. Maybe they'll get Viva and Barnes. Who knows? Hit the road, Jack, and don't you come back, says Feline Fun. Yes, you do. Essential Bite says, love your post. And what's up, Ashley Potter? Is he claiming that he and Fani slept together just to distract people? I don't know. Good to see everybody on X. Who knows what Nathan's doing? Do you think they're still getting the old their indictments on with each other? Probably. All right, so that is what was happening over on X, my friends. Thanks for checking us out over on X and following other watchers out there in the wilderness on the X platform. We got more membos coming in, courtesy of ELLF, Elf in the house. What's up, Elf? Thanks for being a membo, bringing in new membos. We got Troy H is coming in. Delilah C. Mad Hatter's here. Prospering Women is coming in. Jeffrey D. We got Jay. What's up? David H. We got Yukon C, Thomas F, and Tim M, all gifted membos, courtesy of ELF in the house. Great to see you, ELF. And my friends, thank you so much for those incredible donos and all your support. We're very grateful for it. Couldn't do it without you. So thanks for sending those in. We are going over to watchingthewatchers.locals.com, our members-only community, here in a minute to debrief. But before we do, we want to say what's up to our mods and meme smiths before we wrap up the day. Ultra shout-outs go to K-Bean. We got Just Cause in the house, Playing Hooky, Ronnie Cole, Zach Nichols, Janek, Dog Digger, Economy Pilot, Donut Mind Me, Carrie B, and Zulu, all helping mod the fort down for us. Our friends, Sleepy Dog Lee, Nathan N810, Geegum Geegum, Glocky McGlock in the house, and our Dockmaster Elliot. Cliff Norman says, when do we expect the immunity decision from SCOTUS? Any predictions? I think it's probably towards the end of the decision. So we have another batch coming out tomorrow and then another batch coming out. Yeah, there's like 28 decisions left. Maybe not this week, maybe the following week. I don't have a date. I'd have to look at a calendar, but I don't think they're going to come out tomorrow. Let me just say that. I don't have a calendar, but probably just not tomorrow. I think they'll save them closer to the end. Although there's a good argument it could come out tomorrow, because the theory is that maybe they drop the mifepristone case today to give the left a victory. Unanimous mifepristone. Go get your abortion pills. But then they'll come back and drop the immunity decision right after that. So it's like a good cop, bad cop routine. But still, in my gut, I don't think it comes out tomorrow. I think they're probably writing dissents, and it's probably going to still take a little bit of time for editing and all the things. But I don't know. Would be a fun day if it dropped tomorrow. All right, so thank you for that one, my friends. That is the day for us. Tomorrow, show schedule change. So we're going to be early tomorrow. Noon is when we're going to go live. 9 Pacific time, noon Eastern. And we're going to see what Friday has in store for us. Your boys got some afternoon activities to attend to. And so we'll get our early stream in. And then Membos will stick around for an after party to dig into some Membo stuff. But, my friends, that is it for us on the day. Very grateful to have you here join us as we go through this madness. We are going to come back here tomorrow to do it again early. And in order to do that, we're going to need to see you right back here so that together with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. See you right back here in the morning. Bye-bye.